Hi friends, in this video we are going to deal with the important judgment titled as Atbir versus State of NCT of Delhi pronounced on 29th April 2022. In this judgment, the Supreme Court has held that the eligibility for getting remission is not a prerequisite for obtaining furlough. To know more about the case summary, please watch the video fully. The facts of the case would be that the appellant was charged under Section 302 of Indian Penal Code 1860. After trial, Sessions Judge convicted the appellant and awarded death sentence to him. The reference for confirmation of death sentence and the appeal filed by the appellant against his conviction and sentence were decided together by Delhi High Court. The appeal was dismissed and the death sentence was confirmed. Further to that, appeals as filed by the appellant and co-accused were considered and decided by this court. After examining the material placed on record and on analysis of the relevant facts and circumstances, this court confirmed the conviction of the appellant and finding it to be a case falling in rarest of the rare category, confirmed the sentence of death awarded to him, while also confirming the conviction and sentence of life imprisonment awarded to the co-accused. The review and curative petitions filed by the appellant were also dismissed. Thereafter, the appellant filed a petition under Article 72 of the Constitution of India, invoking the powers of the Honorable President of India to grant pardon and to suspend, remit, or commute the sentence. The Honorable President of India was pleased to accept the recommendations of the Ministry of Home Affairs to modify the death sentence awarded to the appellant, and accordingly the death sentence was modified to the one of imprisonment for life, with the requirements that he would remain in prison for the whole of remainder of his natural life without parole, and there shall be no remission of the term of imprisonment. Thereafter, the appellant made an application for grant of furlough in terms of the Delhi Prison Rules 2018. The prayer for grant of furlough was rejected by the Director General of Prisons. Being aggrieved, the appellant preferred a writ petition before the High Court. The High Court held that the appellant was not entitled to seek furlough because he was not entitled to remission. Being aggrieved, the present appeal has been filed with an issue posed for consideration whether the appellant is entitled to furlough under the Delhi Prison Rules 2018 despite bar over any remission in term of imprisonment for the whole of his natural life. The Supreme Court has held that Chapter 19 of the Delhi Prison Rules 2018 deals with the matters concerning parole and furlough. The objectives of parole and furlough set forth in Rules 1197 to 1200 thereof. The specific subject of furlough is further dealt with in Rules 1220 to 1225 of the said Rules of 2018. The matter in its totality shows that once it has been provided by the Honorable President of India that the appellant would remain in prison for whole of the remainder of his natural life without parole and without remission in the term of imprisonment, all his other rights, particularly those emanating from good jail contact as available in the Rules of 2018, stand foreclosed. As rightly pointed out in the Rules of 2018, the eligibility requirement to obtain furlough is of 3 annual good contact reports and not 3 annual good contact remissions. The expressions employed in Class L of Rule 1223 of the Rules of 2018 are that the prisoner ought to maintain good contact in the prison and should have earned rewards in last 3 annual good contact report, and further that he should continue to maintain good contact. Even these expressions cannot be read to mean that the prisoner ought to earn good contact remissions. In the scheme of rules of 2018, it cannot be said that earning rewards is equivalent to earning remissions. Further, it has also rightly been pointed out that when furlough is an incentive towards good jail contact even if the person is otherwise not to get any remission and has to remain in prison for whole of the remainder of his natural life. That does not as a corollary means that his right to seek furlough is foreclosed. Even if he would spend some time on furlough, that will not come to his aid so as to seek remission because of the fact that he has to remain in prison for whole of the remainder of his natural life. Facts on record would show that the appellant is a person convicted of multiple murders. Therefore, the requirement of Rule 1225 of the Rules of 2018 may come into operation. However, it cannot be said that his case would never be considered for furlough. Whether he is to be given furlough on the parameters delineated therein or not is a matter to be examined by the authorities in accordance with law. While disapproving blanket denial of furlough to the appellant in the orders impugned, this court would leave the case of the appellant for grant of furlough open for examination by the authorities concerned in accordance with law. The impugned order as passed by the High Court and the order as passed by the Director General of Prisons are set aside, and the case of the appellant for grant of furlough is restored for reconsideration of said Director General of Prisons. Friends, to conclude, in this video we have seen that the eligibility for getting remission is not a prerequisite for obtaining furlough as per Atbir versus State of NCT of Delhi case. In the next video I will see you with yet another case synopsis. Until then, I take leave of you. Bye.